So in Chapter 3 for business law, if I was being sued for the shoddy work that I did with my construction company, the people that are going to sue me would have to hire an attorney, and then the attorney would have to file a complaint and then serve it to me. When they do this, though, they have to notify me formally. This is called the service of process. Basically, what I'm going to need is a copy of the complaint and a summons as well. When they do notify me, there are acceptable means of service of process. So basically, individual defendant could be served at residence or his principal place of business. A corporate defendant may be served by a serving officer or a registered agent, and a partnership defendant may be served by serving any general partner, by any general partner. So, from there, I would want to hire an attorney. When I do this, though, the attorney may charge one or multiple fees, such as fixed fees or hourly fees or contingency fees. So that's one thing to note. After that, the attorney that I hire is going to file an answer. They're either going to file an answer or a motion to dismiss. Basically, a motion to dismiss is basically asking the court to dismiss the case for a specific reason. Basically, it could be a failure to state the claim properly, just different reasons like that. For whatever reason, that could be a thing that the attorney does. After that, you're going to either admit or deny each allegation that's put against you. On top of that, there is the defendant's response, which would be another thing that you would have to do. You'd have an affirmative defense. So basically, you're going to introduce proof for your side, or you're going to file counterclaims, which you're going to sue them instead. You're going to file like a counterclaim, and then they're going to file a reply back. This could be done for if they don't do the process properly or something along the lines of that. Next, we have different motions on top of the motion to dismiss. There is the motion for judgment on pleadings, and there is also motion for summary judgment. Basically, these things, the first one on the pleadings is to have basically have the judge, the court enter judgment in his or her favor, based off of the pleadings, because of the facts may not be there. So a motion for summary of judgment is a similar thing, just without a trial. There are also other types of motions: motion to dismiss, motion to strike, motion to make more definite, or I can't even read that, this is so small. Motion for summary judgment. So a bunch of different motions that you can file. So that's the first step, which is the pleading step. Next, you have the discovery step. So basically, for the discovery step, Oh, I forgot one thing. Complaints that are filed contain statements or allegations about jurisdiction, legal theory, or remedy. But so that's the first step, which is the pleadings. Next is the discovery. This is the process of obtaining information from the opposing party or from witnesses prior to trial. There are rules to this, however, which must be followed. It must be relevant to the claim or defense for either party. A discovery can involve, from the list here, depositions, interrogations, request for admission, request for documents, objects, or entry, request for examination. So of those, a couple of them would be depositions, sworn testimony recorded by a court reporter, and often by videotape of the parties and other key witnesses. Request for admission would be questions to the responding party phrased in an admit or deny format. There are electronic discoveries, and basically there are rules now that allow for parties to obtain electronic data complaints. Data complaints could be computer generated or electronically recorded information, email, voicemail, tweets, social media posts, a lot of those things like that maybe sometimes people don't really think of. So those are different types of discoveries that can be used. Computers and smartphones and other devices automatically record metadata. This can be also used. So that is the discovery process. Next, we have the conference. The pre-trial conference is a court will typically schedule one or more conferences, which is also known as a hearing, before trial to resolve procedural matters and to narrow the issue for trial. After that, we have the jury. And so for the jury selection, it's the 7th Amendment in the U.S. Constitution, the right to a jury. Most cases, however, are tried without juries, but in specific ones, there are you can request a jury, especially in a federal court. Any trial without a jury is called a bench trial, and basically the judge will make all the decisions. In a jury trial, the judge decides questions of law, but the jury will actually decide all the questions based off of the facts that they receive. The jury selection, most trials are heard by a 6-person jury. You do have you can choose your jury. Basically, you can, if you do choose your jury, you have the ability to dismiss one of them. This can be for no reason at all, or for cause of bias, which would not help your case. You want to choose jurors that would be in favor or more likely to agree with you. But it can't be a discriminatory process. So yeah. There will be opening statements given by both attorneys. Then there are rules of evidence, basically to ensure that any evidence presented is fair and reliable. I'm gonna sneeze. There is the examination of witnesses. The attorney will question each witness as follows: direct examination, cross-examination, and redirect examination and recross examination. There are expert witnesses, people who have like special knowledge or special skills that can potentially help or open up the case a little more and be helpful overall. The defendant will put forth their evidence. Then the witnesses will be called and examined by the defendant's attorney and cross-examined by the people who are suing you, their attorney. There will be rebuttals, and then eventually it will lead to closing arguments. Both sides will present their closing arguments, and the jury or judge, whoever it is, will make their decision based off of the proof and everything like that. The verdict, basically this is what the jury finds. So their findings will be known as the verdict. A jury can award money damages in a civil case or prison in a criminal case. Another thing to note too is that for settlement considerations, basically things that can affect it would be the time and funds of the client, or the defendant's ability to pay the damages sought. This basically will define how much the attorney will spend on given cases. You can have a motion for a new trial. This could be because of an error by the trial judge, newly discovered evidence, or prejudice. Wow, this is a lot. So yeah, basically those are the main steps that I would go through if I was to get sued for that. It's very lengthy, a very long process, but the first thing you'd want to do is definitely hire an attorney. You would go through your trial, and then potentially post-trial motions or an appeal.